Constitution, which we can get into. There's a difference between a charge and a conviction. We may, as citizens, not like that, but then there's the little thing about presumption of innocence. We may not like that. My wife even says, well, how can he or she plead not guilty? We know he did it. Well, that's what we have juries for. I mean, we don't know he did it yet. From a victim standpoint, that's hard to understand and appreciate sometimes. But, if I could fix drug addiction, cocaine usage, lack of family support, grandmothers raising kids, it's sad. And, we as judges can't fix it all.
And I'll add to what Judge Dozier has said. And one thing that I often ask as I see cases that come before me is, where has conflict resolution gone? I remember I was just talking with the general just a few moments ago. I remember when I was a kid, we would sometimes get into a fight at the bus stop, and then the next day we were friends again. We learned how to resolve conflict without resorting to the worst drastic measures. So to add to what Judge Dozier has talked about, I think that there are some things, a lot of things are going on that are not as easy to fix as we would like them to be. Is the system broken? Yes, there are some things that we can do to change it. I'm glad that we have, and thank you to Tennessee Voices for Victims for hosting this panel discussion, because I think it is important that we have these kinds of discussions for the public who may not have a clear understanding of what boundaries within which we as judges and what the court has to, within what we have to work with, in order to try to resolve some of those issues. So these kinds of discussions are very important, and there are and to try to take those measures to try to resolve them. We'll get into it in just a few moments to talk about some of the amendments that have occurred, amendments to our statutes and potential amendment to the Constitution to try to address some of these issues.
I don't concern myself that much with why someone commits the crime. I don't think I have to prove a why. That's a motive. But once something is committed, and I've read the factors in setting bond, and although I agree with the judge that defendants are innocent until proven guilty, but one of the factors is the nature of the offense and the apparent probability of conviction and the likely sentence. Defendant's prior criminal record. I don't know how many times we're having hearings to determine and making the state put on proof and to determine the probability of conviction. So just to say someone is innocent until proven guilty, although true, there are mechanisms in place to have a hearing so the court can get a view of the evidence against this defendant and then set a bond according to that. Now, of course, we're going to have a jury and they'll decide guilt. But we're talking the initial phases of this to where someone's been arrested. There's obviously a violent crime. And not to mention if someone is on bond and just been released on bond and commits another violent crime, I think he's forfeited his right to, or her right to bond. That's my approach where I'm from. Now, I don't live in the same place everybody lives across Tennessee, but that's the approach that I give my prosecutors. And that's the approach that I've relayed to the judges in my jurisdiction. That's my job, to enforce these laws. And I don't know how we got here to where we think we can just release violent criminals. just by saying they haven't been proven guilty yet. There are mechanisms to do it, if we do it.
I don't know any judges that will purposely release violent offenders into the community. The statute sets out the guidelines for setting bond. I think the question asked, and I agree with the judges, is well, why are these bond offenses happening? Is it the judge's fault, the court's fault? No. I believe truly that there's young people that have not learned to love themselves, haven't learned the ability to love or learn the value of others' lives or their property lives, and we're receiving this into the justice system. And again, when they do come into the justice system, and a bond is supposed to be determined, the magistrate sometimes has a very short period of time to determine what we have here, what the charges are, and how many of these factors apply. I believe in a violent offender who has a prior record or is on bond. It may be they slipped through. I don't know. But to address the number of crimes we're having now, especially with the younger folks, we have some societal issues, some issues that have to be addressed, and it's not necessarily going to be fixed by the legislature or the court system. We got to deal with it. And when they do come in with violent offenses, we have those statutory guidelines that say how things be done. If the facts support a strong likelihood of conviction, it's a heinous crime, the fine should be high. Sometimes because of humanity, the people that are making decisions in a short period of time, they may slip through. But we're having more of these young individuals and individuals committing these crimes that are making the news. And we do need to recognize that there's some societal issues that may be the focus and we have to deal with.
Spoke earlier, Judge Osher, about following the law. In 11 days, we have a whole slew of new laws. For instance, that now public safety is supposed to be the number one consideration in setting money. There's still going to be judicial discretion.
It is in Division 1.
Pardon me?
I said it is in Division 1.
Do you think that, is there enough discretion to work around that, or do you think that now becomes the banner on setting these bonds, considering the low bonds we've seen for incredibly violent people? We've seen some super low bonds, especially at the magistrate level.
Just from a procedural level, Judge Dalton and I are in criminal court. 95% of the people arrested are by warrants, not direct presentments to the grand jury. They go through a magistrate, a night court magistrate, who may or may not have a lot of information. Come through general sessions court. Sometimes the bonds are reduced, probably not ever raised. So we get them, we're in an adversarial system. By that I mean defense attorneys, district attorneys. Judges only can decide what's presented before them. And the general is right in that if someone's out on bond, there is a statute currently in a state Supreme Court case that affirmed the constitutionality of that statute that says if you commit a new offense while you're out on bond, your bond may, it's up to the judge's discretion, be revoked. You have forfeited your right, your constitutional right to bail if you commit a new offense. And there's a showing in the adversarial system that they've done that. 8 out of 10 times in Division 1, they're revoked. So does that happen in general sessions? I don't know. I mean, could there be better ways to the DA's office to have an alert system to monitor cases? I know cases that are in the news and people out from November 23, May 24, and then June of 24. If we're presented a motion to revoke their bond, we're going to hear it. But I don't have the capabilities of, and shouldn't be, looking at people's records and monitoring whether they've gotten rearrested. I mean, that's up to the DA's office.
And that's a great point. You are only responsible for your own court. I guess, like most of the people here have worked for people, there has to be some supervision. The magistrates are supervised. If the magistrates are setting continually low bond, what is our recourse as citizens if people feel like this is happening over and over again?
I'm not over the magic.
Information is unbelievably important, and we're not involved in the magisterial process either. The defense attorneys are not there. Very rarely do you go down and turn your defendant in. If you do, it's usually someone who has a reason to have a low bond and they've already retained your services. The vast majority of the time, the police officers, the arresting officers bring the defendant in, and the bond is set there by the magistrate based on information they may or may not have. If someone does not, if they make bond, they make bond. And then if they're out doing wrong, hopefully the district attorney's office, others will pick up on it. And it could be it's about information gathering. And maybe there needs to be a bond liaison in the DA's office that looks at people out on bond, run their names, see if they've had new arrests. But it becomes a situation when the system has to deal with people that are not doing well. But typically, I'm a defense attorney. One of my clients is out and commits new crimes. I just received 2 today. There's motions to revoke and increase bond. I have to go in and see if I'm going to be able to keep my client out on bond. And typically, speak to these 2 judges, if they mess up in a big way, they're probably going to have their bond revoked or increased.
Well, if we have magistrates and judicial commissioners that are being presented a warrant for a violent offense, if somebody's on bond and they're still giving low bonds, how do we get rid of these people? I mean, what's causing that mentality? I don't know. Somebody's gonna have to talk to them. Just because they make the bond. And then you have to understand, once it goes through as a warrant through general sessions, what's the likelihood if the defendant appears on this low bond and doesn't miss court? Is the general sessions judge going to raise the bond because now they know the proof? No. Because he's appeared. So I guess the bond has served its purpose, which is one of them is to ensure the appearance. So this person will go all the way through on the streets, and I think I've seen in the newspaper here in Davidson County, there's one individual, this happened 4 times, committed crimes within a short period of time and was bonded out. So maybe we need to look into who is the magistrate, who are the judicial commissioners. I don't know if you're aware of what's going on in Memphis right now. Same type of thing. And other places in the country. But who's setting these initial low bonds? Now, the judge is right. He's not going to check the book of law every day to see which one it is. But the court, in that revocation statute, as Justice Lee interpreted in 2015 in that case, was the court can sua sponte have a hearing to revoke a defendant's bond. Now, or at least ask the state, put on some proof of this arrest. But normally it is our responsibility because we work closely with law enforcement. And in my jurisdiction, we do it. We revoke bonds, or at least bring it to the court's attention to revoke bonds, both in general sessions and in circuit court. Most recently, had an individual on bond for a substantial amount, a young person, and had GPS monitoring. That was for a first-degree murder charge. He missed court and cut the monitor off on the same day. Now, we revoked his bond, but he is now loose on the streets. So, there's some consequences to what we do. And I know I'm the prosecutor, so I'm going to be tougher. Bobby's job is to advocate for his client. The judges are to be fair and administer the law. But it seems like we've got a little out of control. I don't don't know where the philosophy comes where we can let violent criminals out, especially on low or no bond. We're going in the wrong direction if the country's doing that.
5 new laws in 10 days, 3 different perspectives. How do you see the application of those laws changing anything in the landscape of bail and bond?
The one statute you're speaking of where the legislature removed the court considering financial considerations of the defendant, that's hard to factor in anyway, as it currently exists. You know, the argument is, well, if it's a $50,000 bond and I'm rich or I have money, I would have already made it. But I don't have, let me back up a second. Maybe all of you know this, but the bonding industry in Tennessee is very strong in terms of lobbyists. You don't want to pick a fight against the bondsman, okay? The statute allows for them to charge a maximum amount of 10%. So if there's a $50,000 bond, they can put up $5,000 with the bonding company and be out. Some apparently, that I've heard anecdotally, not just in Davidson, but across the state, you're getting now into bonding companies bargaining against each other. Well, I'll charge you 5%. Some as low, I've heard of 2%. So it's a money-making thing for bondsmen. They serve a purpose. They track them down. They have to pay extradition costs. There's a lot of good purposes for bondsmen, but they fight laws that would put them out of business or reduce the amount of money they can make. The constitutional amendment that was voted on this session has to be voted on in 2025 and then can come up for a statewide vote in 2026 if it's passed by a 2/3 majority in 2025. Adds, and this group, Verna and Valerie's group, I'm thinking would be behind that constitutional amendment, adding 20 new offenses to the Constitution that allows courts not to set bonds. Most all Class A felonies, ag rape, murder second, aggravated kidnapping, all of those now you think, well, why do you set bonds on those now? Because the Constitution requires us to. It may be high. I had a gentleman not too long ago make a $2 million bond. I set it that high, he made it. But there's tons of factors, bonding industry, lobbyists, they're against that constitutional amendment. But if that passes, we would, as judges, have the capability of denying bond on a child rape or especially aggravated kidnapping involving a weapon or injury, things like that we now don't have the capability of doing. But I don't know if the others specifically you were asked about.
Well, no, that's fine. I kind of left it open because there's 5. One is, the Jillian's Law, right? Where you've been kind of hamstrung in if someone's mentally incompetent, if Mr. Taylor is mentally incompetent, committed an egregious crime, right? And then he came back and killed that Jillian Ludwig, that freshman student. So